All right. Question number 2 of the evening comes from Mad as Hell in Brighton. And he or she says,
Hmm.
about a month ago, I filed an eviction against my tenant. While we were waiting for a court hearing date, she agreed to leave the property so long as I did not pursue her for back rent. And I agreed. She left last weekend, taking all of her property with her. I had the locks changed about a day later, but I just got a call from her attorney who is now suing me for a lockout. What do I do now? From Mad as Hell in Brighton.
Hmm. Well, that's a good one. That happens quite often, actually. It's called, the Michigan anti-lockout statute prevents landlords, both commercial and residential, from locking their tenants out. And the damages, the punitive damages, are significant. Usually, it's treble damages. So, if let's say a landlord locked a tenant out whose monthly rent was, let's say, $1,000 a month, that lockout could cost the landlord $3,000. Okay, just so it's usually treble damages. I have actually had cases with treble damages going up to $75,000. Right, so you have to be very careful as a landlord. This goes along with the question number 1. How do you know when you're done with your contract? How do you know that you're done with your tenant? Usually the best thing to do, again, is have things in writing. Another way to get to confirm that it wasn't a lockout is, did the tenant give a key? If the tenant handed a key, that's a form of abandonment or relinquishing the property. The problem is that in this fact pattern, I hear that this lady went and she changed the locks. So, it's going to be one person's word against another. The concern is, probably the best thing to do is get a witness, or have like a cash for keys type scenario where you have a realtor go and have the tenant sign a document that says, I'm done. I'm leaving on my own volition. Again, this is a document that can be created by an attorney. It's very brief. I'm leaving on my own volition. I'm abandoning, in so many ways, I'm abandoning or I'm forgoing any of my rights and defenses under the lease. These are things that have to be written properly so you don't have this issue. So Mad as Hell in Brighton, you probably did the right thing initially, or you thought you did. You said, hey, I'm not going to collect on any back rent if you leave. That's not enough, because if nobody has anything in writing,
Right.
you're in trouble. So it's another one, get it in writing. I have a tagline on a lot of my ads that will say, call call us before you sign. But it really should be just get it in writing. I can't fit that on my license plate, though.
Get it in writing.
Vanity.
How do we smush that down to like 7 to 9 characters or whatever a license plate is?
I know. I actually have a domain name called iwishicalledyouSooner.com.
You could get a car wrap for your car. You know how some businesses wrap their car in like their logo and graphic?
That's not going to happen.
Get it in writing, wrapped around your
That's not going to happen. I'm sorry. But call before you sign, or get everything in writing. And if you're really unsure, at least go get a witness, or we can use text and everything. People text back and forth, and we use that very often in court actions as evidence. And so many things come up from a text. So we've settled so many transactions with other parties. We'll be like, hey, did you see this text? And all of a sudden it changes the whole playing board. So get it in writing.
That is like a sidebar question that I have been thinking about lately. We text ourselves personally back and forth with so many of the people that we do business with, and I've often thought, are text messages even admissible in court, or does it have to be in an email?
No, they're admissible.
You can use, okay.
In fact, there's a law. I actually have a really intense case going on right now where my client actually recorded the other party in a conversation. And in Michigan, there is an anti-eavesdropping law that basically says that you cannot use recorded conversations without the permission of the other party. But the courts have actually interpreted that to mean you cannot, if you're a party to the transaction, you can record without the permission. But if you're not a party to the transaction, you're a third-party eavesdropper, that
I
is not
see.
admissible. And
I
we have a situation right now where we're going into court arguing about whether or not this very damning conversation is admissible in court. And quite frankly, it is. But the other side, you know, who's
It's
very
fighting it.
seasoned, has never had to deal with this issue, and believes that that's not the case. The case law is in our favor. But yeah, you can record so long as you're part of the conversation. There is some new case law that has discussed this, but still the law is that way. I'm not here to. By the way, we disclaim everything. I just want you to know all the information you get from me. While I'd like to think it's extremely coming from a good source. You should always consult with your own attorney before you rely on the information that is presented, right, Blair?
Exactly. We are not practicing law over YouTube at the moment. Exactly. So whether you call David or you call another attorney,
Right.
And whether you're watching David's videos or another attorney's videos, definitely speak with your own.
Or get a Facebook attorney. Get a Facebook.
Right. Just hop on Facebook, lob your questions out there, and let your friends and family chime in. Exactly. We're joking. We're joking,
Right.
folks.
But that's a great question. Sorry about that. Your situation there, though. Anyways.
Yep. No, that is unfortunate.